All right. Perfect.
Well, welcome to the South Florida Hospital News Legal Series with the Broward County Medical Association as a supporting sponsor and presented by Mirza Healthcare Law Partners, who's the and Ben Mirza, who is the managing partner. Our legal series presents the issues facing doctors and other healthcare professionals in Florida. The webinars are 1 hour starting at 6:30 on the first and third Tuesday of every month. Today, we welcome Ben Mirza and his associates. Ben, it's all yours. Take it over.
Good afternoon, everyone, or good evening. Thank you for making the time today to join us. Given that it's late in the evening, I know everybody's got a dinner and family to get to. So we're going to try to make this as quick and painless as possible, and as succinct and impactful as we can. Today our goal is to actually get you acclimated to how medical staff bylaws work, and the reason why I think it's so important is because the turf battle that's being fought out in this industry, you're all going to want to tune into it. You're probably seeing it play out in front of you, or you will sooner or later, one way or another. So with that said, let me get us started on the presentation. All right. Okay. Can you see that?
Yeah.
All good? Okay. So yeah, so today we're going to be talking about protecting your rights, ins and outs of medical staff bylaws, and we'll also talk about the Joint Commission and how the Joint Commission is also playing a role into this. So with that said, a little bit about who we are and what we do. Our group is called Mirza Healthcare Law Partners. I am actually an attorney, a former CPA, a former certified healthcare compliance officer. I've been an attorney for over 20 years. I've done a lot of contracts and a lot of litigation work over the years. So I won't bore you with my stuff, but you can see it on there. I mean, I've got a few degrees and all that sort of stuff. But the person that I'm really, really excited about is Ed. Ed Meyer is actually, it's an honor to have him. He's just a wonderful and a wealth full of information sort of a person. He is our go-to person whenever I have questions, and I've been in the industry obviously for a long time, but Ed is always great to bounce things off of. With that said, Ed, you want to maybe
thank
give a
you.
more formal introduction?
Thank you, Ben. Yeah, my name is Ed Meyer. I'm of counsel to Mirza Healthcare Law Partners, and practice next month. I'll be my 30th year of practicing healthcare law. Even before I started practicing healthcare law, I worked for a member of the House Ways and Means Committee as they were putting together some of the laws that were actually govern us today. And then I worked in the Reagan administration at the U.S. Department of Health and Human Services while I was actually going to Georgetown Law at night, and started my law career in 91 and have been practicing basically exclusively in healthcare law on the regulatory side. I'm not a litigator. I deal with the regulatory and business side. I am licensed in California, and I've worked for several different organizations, hospitals, health systems, individual physicians, national physician groups, small physician groups, as well as other types of licensees. But let me introduce you to our associate, Komal Mirza.
Good afternoon or evening now. My name is Komal Mirza. I am an attorney with Healthcare Law Partners, and my primary practice area is in employment law and risk management. And while I've known Ben since before he took on the Charlie Crist look, I consider myself a Ed Junior, and especially because I was actually at the table when the Affordable Health Care Act was being proposed in Congress at the time as a U.S. congressional intern. Thank you.
Wonderful.
As a note, please take note that this presentation is intended for general informational and educational purposes. We are not providing any legal advice today, so if you have any particular personal issues or concerns that you would like to discuss, please feel free to call us at any time. And also, as a note, please take notice that the seminar is open, live, and being recorded, and will be used as a public online resource in the future.
Thank you, Komal. As we start off today, I think when we're planning out today's seminar, and including my discussions with Ed and Charles and Komal, we talked about actually doing a case analysis right up front and walking through a practical sort of a situation. And so we're going to spend a few minutes on this slide before we actually go through the formalities of what you're going to learn. And this case analysis is really intended to kind of walk you through the potential pitfalls that arise and then the mechanisms that are in place inside hospital systems and mechanisms outside of hospitals that are in place that that you can utilize depending on which side of the fence you're on to actually help your situation or help your friends along the way. So this case analysis actually started from a real situation that we had. There was a physician that came to us a few years ago, and the thing that happened there was he was being investigated for changing of patient notes. Okay, so from his perspective, he actually had a really high volume of patients. The hospital was under a financial pressure to make physicians submit notes faster so they could turn around the billing faster. And almost all of his notes were turned in timely. There was no issue as in 99+ % of those patient notes. But every now and then he would actually recollect something, and he would see some sort of results, and he'd go back in and he would actually modify the record later on. Now, as Ed will talk about this, there's more than one way to actually modify a record. But his thinking was all he was doing was improving the accuracy of his notes in the best interest of his patient, and it was occurring on a very rare occasion. From the hospital's perspective.
Yes, let me talk from the hospital's perspective. So from the hospital's perspective, first of all, they're getting a complaint. They're hearing that there's a physician changing the medical record. All right. So that's what they're looking at. They're going, oh, it's changing the medical record. So they start looking into these things. And the hospitals, their license, they got to keep their license. So they have to follow the rules of their license, the rules that they have established. So those rules say certain things have to be done with regard to medical records. Physicians can change medical records so long as there's delineations in the record, so you can see what was originally there and how it might have been modified. But when one changes something where you're not a delineation, or they're looking at it and they're saying, oh wow, this may be upcoding or things like that, they get real concerned. So because it does affect how they end up billing on the hospital component. So they follow the rules. They say there's a process they need to follow. Start an investigation if they're not initially satisfied with an explanation. Start the process. Go to the MEC to do the investigation, and bottom line is got to follow the rules.
So when that issue got reported, the MEC put together an investigation committee. They investigated. So if you see over here in part 1, we talk about the MEC action. What did the MEC do and how did they get involved? So the MEC, what they did is they started an investigation. The investigation committee went out and they searched through the facts, and they're supposed to present only the facts to the MEC. So the investigation committee reports to the MEC, and then they present them the facts. Now, based on those facts, the MEC is supposed to make a decision: either do nothing, do something soft, or do something harsh, which is generally means like a long time sort of a suspension. Now, in this particular situation, what they did is they actually said, we're going to terminate this physician's privileges, and that's a pretty severe sanction for something that, from our perspective or my client's perspective, was it could have been handled very differently. And we're going to talk about how that situation could have been handled very differently. So what happened is they called they sent him a notice of reasons, and then through that started the whole process. And they actually got rid of him. So there are ways to actually fight this sort of a scenario. The way you do it is you go through exchanging of documents, and what you do is you get a hearing panel and you get a hearing judge, which are all supposed to be nonpartisan individuals coming from other places, not anybody having an interest within the actual hospital itself. And there's a way to actually present the facts and debate the facts and have non-hospital folks actually decide what was the right way to address this issue. Now, given all that, this is actually part one under the MEC section, as you see over here. You know, it can actually have a fairly reasonably high cost to it, and it can run $25,000 plus, and it's pretty expensive. But it's you know, given that somebody's license is on the line, it becomes important, and I'll tell you why. If someone's rights get terminated for privilege rights get terminated, it is a reportable issue to the National Provider Data Bank, the NPDB. And because that's reportable to the NPDB, now you're cited as somebody who's had like a serious violation occur. Then going to another hospital system and getting picked up or getting privileges in that hospital system becomes so much harder. I mean, it's just a lot harder if there's an NPDB issue in the background. So under the MEC action side, there could have been things done about it, but in this case, what the physician decided to do is he just decided to leave the system. And Ed, what happens when you leave the system?
If you leave the system during an investigation, even if you played it out and nothing would have happened, but if you leave when a formal investigation under the peer review started, that in of itself makes the event a reportable event to the NTBD. So I've had clients who come to me after they've left, you know, saying, hey, I don't have to deal with this. I could work in any hospital. So they just leave and leave the medical staff. And all of a sudden they've got reported on something which they had believed would have been minor. So if once an investigation starts, you know, you got to play it through, which is also important because sometimes when there's a matter that's important that you think might lead to an investigation, perhaps you might want to get your attorneys and the hospital attorneys and the physician attorneys, the physician-employer attorneys to get together pretty quickly and see what they might be able to resolve this before it even gets to the formal investigation stage.
So let's say that under the MEC scenario, when the physician is actually terminated and they have to leave the hospital, there are other avenues available to them. They can still appeal that decision. Within the actual hospital staff bylaws, there will be other avenues to do it. But the next step to do is to actually take the appeal outside of the system and take it to a court. And that's where, you know, you'll definitely need an attorney if that's the actual situation, regardless of which side of the fence you're on, whether you're on the hospital side or the physician side, but there would definitely be a need for an attorney. And there, what you have to do is you have to make sure that because there's an adverse decision that you've exhausted all administrative remedy first. Then once that's done, what you do is you actually let them know that, hey, I'm going to be filing a lawsuit, and the lawsuit is going to have probably a breach of contract claim in it, denial of due process, a retaliation claim maybe, or maybe an employment or a civil rights claim in it as well, depending on the circumstances. But these are the typical claims that get presented before the court. Now, most hospital staff bylaws say that you have to do this within a 30-day period. So you have to read the bylaws, see what they actually say. But most will say about 30 days is how much time they give you to file the suit. And if you don't, then you get automatically reported to the National Practitioner Data Bank. So in that particular situation, the court can actually, if you proceed to court, the court can overturn the MEC or the MEC's decision. And what happens is everything starts anew. The whole case starts from brand new, from scratch. So all of the actual discovery starts to happen. All of the documents are shared, depositions are had, expert witnesses come in, et cetera, et cetera. And it goes on. I mean, you'd end up, that could be a costly battle as well. It could cost anywhere from $30,000 to $100,000. And depending on the set of circumstances that you're looking at, you're still looking at something sizable. Now, mind you, you're looking at spending this kind of money between 30 and 100,000, let's say, over probably about a year and a half's worth of time, because it will take time to resolve this, maybe even longer. It might even be like 2 years. I've seen cases that have lasted as short as 7-8 months, and I've seen them go as long as 2 years, 2.5 years.
So seeing this, it's real important to understand, as you see this is a long process. If a physician really sticks his feet in the sand and says, look, I want to make sure my rights are completely protected. So there's an incentive in the hospitals to figure out ways to kind of reduce this. And one way that I've often seen is in the hospital contracting area. So the hospital contracts, let's say for a coverage agreement, let's say if you're a hospital-based emergency department, emergency group, radiology group, or anesthesia group or pathology group, you're hospital-based, and you have a coverage agreement with the hospital to cover that, and to say it's in a closed system, you're closed and it's exclusive to the group. The hospital will oftentimes put in provisions that'll say something like, hey, if there's a complaint or if there's some default by a particular physician or misbehavior by a physician, that the hospital could exclude that physician from the contract if they're an employed physician, which means effectively, yes, they still have, I guess they're still a member of the medical staff, but they have no ability to work in the department to which they are privileged. And that circumvents a lot of this process. So it's just the key thing for the physicians to keep in mind is that to make sure that when you have contracts with a hospital, to see what you can, to get your folks to see what they can do to embed in those contracts, some fair processes. So if the hospital administrator has a problem with a physician, that there's some process, some meet and confer and due process, so the physician's side can be well vetted. But again, there's an incentive on the hospital from the hospital perspective to try through contracts to get around some of these due process provisions.
So, believe it or not, the market forces that are in place today, meaning like the shifting of payment structures and the way physicians are seeking to outside physicians are seeking to get inside hospitals, and the way the economics of it are all working out, it's literally a turf battle inside hospitals. It's a very real economic reality. Okay, so don't kid yourself. I've been on the inside of hospital systems, and I've been on the outside, and there's always a few people that don't get along, and for whatever reason, and it could be something solid or it could be nothing, it could be almost something small, and people will get pushed around. So the reason why we are talking about this today is to actually make you and help you get more equipped for when you're in a situation, whether you're leading the hospital side or your own practice by having privileges inside a hospital, that you actually understand the lay of the land and the mechanisms that are in play. So today's roadmap is this. We've already done this case analysis, which is, I think, one of the very, very, very critical parts of understanding what we're going to talk about next. But now we're going to walk you through the mechanisms that affected that case analysis, what and how to look at those things. So we're going to talk about governing documents, credentialing and privileging, and you'll pick up nuances. This is all familiar to you, but you're going to pick up nuances that us attorneys look for when it comes to medical staff issues. We'll walk you through how investigations are supposed to happen, how disciplinary action takes place, and then the appeal rights that come out of it. So in the end, we're going to cover the rest of this in about 35 minutes, and you're almost halfway home. We promise to get you to dinner soon.
Yes. So we're going to talk about the medical staff bylaws first. So what are the medical staff bylaws? Why do we have medical staff bylaws? Well, because you have a medical staff, and that medical staff needs to be organized. It needs to be how to govern that staff, how to privilege the staff, how to set up the requirements for membership, how to set up disciplinary matters, how to set up the departments. So what those medical staff does, its bylaws do, is takes that association of healthcare professionals that are in the hospital, the physicians, and organizes them in an organized manner. Now, what's in the medical staff bylaws is largely affected by law. The Medicare conditions of participation govern what require if for the hospital to be licensed to participate in Medicare. It says this is what has to be in your bylaws. Similarly, you have state and laws and administrative codes that affect what's in the bylaws. Next slide. So, for example, so you have the medical staff bylaws, and let me make a distinction between the medical staff bylaws and the hospital bylaws and the hospital policies and procedures. The medical staff bylaws are effectively an agreement. Some states it's not considered a contract. Other states they are considered contracts. Como will talk about how Florida views them, but it's an agreement. It's how the staff itself is organized. But what has to happen is it has to be developed by a collaborative process between the medical staff and the hospital board of directors. So the hospital board of directors, hospital board of trustees cannot simply tell the medical staff, this is what you must have in your bylaws. The medical staff itself must be at the table as those bylaws are developed. Similarly, the medical staff has their rules and regulations that are outside of the bylaws, but again, how some sort of details, like say about some protocols, how some departments might be set up, etc. Separately, you have the hospital bylaws. The hospital bylaws are the corporate bylaws of the hospital as a corporate organization. How the board is set up, how it regulates the executives and the people who are within the hospital, other than as the medical staff is set up. And it also has their policy procedures. The difference between the medical staff bylaws and the hospital bylaws is the hospital bylaws are unilaterally set by the governing body of the hospital. They dictate it. Similarly, again, with the medical staff bylaws, any amendments to those bylaws must be done collaboratively. Again, for those interested in really getting into what has to be in these bylaws, you can take a look at the Medicare conditions of participation, which govern the requirements for both the governing body and the medical staff that I gave you citations right here. In addition, you have the Joint Commission. The Joint Commission, which is the accrediting body authorized by CMS to evaluate the hospitals meeting the minimum requirements for participation, they will go in and look at the bylaws and ensure that they were developed through a governing body and medical staff collaboration. But they will also make sure that the requirements that are set out in more detail, that are the comprehensive accreditation manual for hospitals, that those requirements are set out in it. In addition, you have the Healthcare Quality Improvement Act. As we'll talk about later, you have the due process and hearing rights. So what happened a few years ago, it probably wasn't a few years ago for me, when I was early practicing law, actually before I was practicing law, when I was working on Capitol Hill, there was a big issue with regard to the peer review, because peer review was going on by physicians, but the physicians who were being reviewed would go turn around and sue the physicians who were on those hearing panels, saying, hey, look, you're really trying to just get me out of business, and I have a lawsuit against you for economic harm. So Congress looked at this and said, and there was a Supreme Court decision, but then Congress stepped over and says, you know what, we need to immunize those physicians who are participating in peer review so that they cannot be sued. But to make sure that they're acting properly, the Healthcare Quality Improvement Act sets out the requirements for fair hearings and due process when these peer review and privileging occurs. So that also is one of the driving forces of what's in the bylaws, as well as the National Practitioner Data Bank reporting requirements.
Yeah, so the NPDB came out of the HCQIA.
Yeah.
The act. Okay.
And I let Como address the Florida law issues with regard to medical staff bylaws.
You, Ed. So the medical staff bylaws in the state of Florida are actually looked at as contractual agreements between the medical staff and the hospital system. And this is largely because, as Ed mentioned, there is a requirement for there to be a mutual agreement between both entities for the medical bylaws to be adopted or amended. It is important to note that because there has to be a mutual agreement between both entities, both the medical staff and the hospital system, before the bylaws are adopted or amended, that means that there cannot be a unilateral decision by either party. The medical staff cannot adopt or amend a bylaw without involving the BOG or the Board of Governors. And the Board of Governors cannot do the same without involving the medical staff in the process. The purpose of, as I highlighted earlier, the medical staff bylaws purpose is to ensure that the expected quality of healthcare is maintained, and that's primarily accomplished, again, through the bylaws. What is important to note that Florida law and Florida courts look at whether due process rights for medical staff are clearly enumerated and provided for in the bylaws. So while you're adopting or amending your bylaws, you do want to make sure that you are enumerating and clearly stating what the due process rights of medical staff are.
So, and again, from the hospital perspective, it's important for the hospital to make sure the bylaws are set up according to the legal requirements for the bylaws, because that is a mode of attack when there is an adverse action against a physician, where the physician council will look and say, well, look, the bylaws are not set up correctly. So it's very important. But so the bylaws, one part of the bylaws, a couple parts of the bylaws, what do? They set up the staff categories. They set up the departments that are in the hospital, that are within the hospital, into, let's say, the general surgery or neuro, ortho, et cetera, and the staff categories, and also the privileging and credentialing for that. So the common ones, obviously, are the active staff, which, are the physicians who have the ability to admit patients into the hospital and do procedures within the hospital, the right to vote and serve on committees. And oftentimes, to be an active staff, you must have a certain attendance requirements and certain participation requirements to be able to continue, as well as certain numbers of procedures that must have been done in the hospital, some minimum number of procedures that must be done so that there is a continued oversight in your professional clinical care. The provisional staff is the initial entry into the active staff category, where there's oversight into the clinical care as someone's brand new to the medical staff, to make sure that active staff member with admitting privileges, the ability to do operations or procedures within the hospital, is clinically competent, not just by the privileging done, but also the review. Then there's a consulting staff, where they may have you need an expert come in who has a particular expertise and assist the other physicians, the active staff members, to consult with regard to how so maybe some new procedures that's being developed can be done. They don't usually have a right to vote on the medical staff governance, but maybe be required to attend meetings. There's also an honorary staff category that's usually done for physicians who have been on the staff for years and years, and who have the institutional knowledge and the ability to provide guidance to the others. It's like like a emeritus member of the medical staff. Again, they don't have the ability to vote or privileges, but they are there to be involved professionally in the professional oversight of physicians. And I'll let Colm talk about a couple other very interesting categories that are actually getting more play today.
So the two remaining categories for medical staff membership is disaster privileges, which is enumerated in the medical staff bylaws as to how and when these privileges are provided to physicians or healthcare providers. And typically the bylaws will set up a committee, part of the medical executive committee, a subcommittee of that will help identify and give privileges, disaster privileges specifically to healthcare providers in the event of something occurring. Of course, we've seen a lot of these privileges being granted during this current COVID-19 pandemic. Another privilege to keep in mind is the telemedicine privilege. While it has been around for a few years, we've seen it more so in the last year or so because of COVID-19. And the main thing you want to keep in mind when it comes to telemedicine privileges, you want to make sure that the healthcare provider that you're granting those privileges to is actually licensed in the state to provide those services. So meaning if the provider, for example, is located in Washington, D.C., but they're going to be providing services to patients via telemedicine in the state of Florida, you have to make sure that that provider is licensed in the state of Florida before granting them those privileges.
So again, you also have the medical executive committee, the medical staff committees, and their officers. Obviously, there's the medical executive committee, which is the governing committee for the medical staff, and it sets up the subcommittees that report to them, such as the subcommittee for quality, subcommittee for reviews the bylaws, and the peer review committees, the formal peer review committee, or maybe an ad hoc committee on peer review, health and wellness, or for physician health, physician behavior, physician wellness. There's the chief of staff is on that committee, and as well as other enumerated officers for the medical staff. But the MEC is the key committee for that organizes the staff, holds the meetings, and governs the staff itself, and reports up to the board of directors. There's credentialing and privileging. The key difference between the credentialing and privileging is really the gathering of and verifying of the information about the qualifications for the physicians and the professional practitioners on the staff. This is all required by CMS, that they must credential and privilege the physicians and the allied health professionals on the staff. Their physicians are credentialed, that means they're verified, their professional, their degrees or their qualifications. But then there's privileging, where privileging is basically the identification of the services, the scope of services that can be done by that physician in the hospital in a particular department. Privileging can only be within the scope of that physician's professional license. Similarly, they can only privilege physicians within the scope of the hospital's license. So, for example, if the hospital is not licensed as a tertiary care unit, they can't privilege physicians to provide tertiary care. Or if they're doing heart transplants, they have to be licensed for that. They can't just start privileging physicians to do those in the hospital.
Okay, so as Ed touched on, this is how the privileging process works. First, obviously, there's a gathering of information, like Ed said, but in the gathering of information, there's actually really, really important information that's being shared. There's going to be authorization forms, there's going to be disclosure forms, there's going to be release of liability forms, and then last but not least, there's also an acknowledgement by the incoming physician that they have read and understood the medical staff bylaws. So in the credentialing application, it's really important to be as clear and as truthful as possible. And if there is something in the past that you need to actually have mentioned, make sure you run it by somebody else, through somebody else, somebody that's like good counsel. Reach out to your attorney, make sure you contact them so you can actually make sure that the way you're framing it in the application, that you're not just glossing over it, but you're also not laying in front of the train either. So as Ed would,
yeah, that's a really important. Cannot lie. You cannot mislead on that credentialing application, because that can come back and haunt the physician. That authorization form, the form that's filled out by the physician. If you had something in your past, such as a disciplinary action that got reported, or they're asking a question, you have to write it down. But talk to counsel. but how you might want to not just write it down, but also provide an explanation, especially if it's happened many years ago, and then add perhaps if there was a coursework that you did to correct it, that you add this coursework, stuff like that.
So then once the information is gathered, then what happens is then it's verified, right? So somebody on the inside the hospital system will actually sit down and verify all of these bits of information. And sometimes it's just one person or multiple people handling different aspects of that file. And they will go through it, and sometimes they will miss stuff, and sometimes they will get the wrong person's name and the wrong stuff. So you got to be mindful of that, understanding that part of the process. Once that information is all gathered, it's put together into a nice tight file, and it's forwarded to the department chair. And the department chair will take the application file and look at it for completeness. So they will review and make sure that all of the I's have been dotted, T's have been crossed. Up to this point, the application can actually be withdrawn or discarded for lackness of a complete application. However, if we go on to step 4, where it goes before the MEC, and the MEC then decides on that file, and it's a negative decision, at step 4, it's got to get reported. So now you're going to that enters into a whole other rabbit hole. And you got to be mindful of that. So either way, whatever that MEC's decision is on that file, it gets reported to the Board of Governors, and the Board of Governors will generally rubber stamp that decision from the MEC. So keep in mind, there is a slippery sort of a situation between here on step 4 that you want to be aware of. Understand, to the extent that you can, you may want to get your application vetted ahead of time and see how you would fit into it and whether you would actually qualify and all that. So you want to get a really nice feel for it before you even apply. This step 4 is the part that I would actually only go into it knowing that you're going to get approved. If you think that you're not, then you got to work through other angles. And if you have any questions, you may want to reach out to your counsel or call your tech guy, call one of us, and we'll take.
And from the hospital perspective, in a professional liability lawsuit, malpractice claim, the plaintiff's counsel will often try to attempt to put in a claim of negligent privileging, that credentially the person was not really credentialed correctly, so this is why it's so important for the hospital to have a very organized manner in which they get the application, in which they actually verify the information, that the department chair takes that active role, that the medical staff committee does its complete review, so that they can have a defense on any claim of negligent credentialing of a physician on their medical staff.
Now, if someone does get denied, they do have the ability to, they do have recourse to actually refute that. But that's another appeal process, and you have to go through the whole other steps for it, and we'll cover them shortly. So in credentialing, just make sure, remember, it's when it comes to credentialing, they're looking for 5 things. And these are actually spelled out by CMS, and I think also by the Joint Commission, says it in their rules and regs too, that basically the application has to be evaluated for character, competence, training, experience, and judgment. Those are the 5 things that they're going to be looking for. They've got to have a nicely laid out criteria for what they do want. And then this credentialing has to be redone every 24 months. CMS actually requires that. So the hospital, also keep in mind, as Ed had said earlier, a hospital cannot grant privileges that it itself does not have. So for example, if there is no ability to actually transplant organs, you cannot give somebody else the ability to actually transplant organs in your hospital. Things that are obvious, but it does happen. Yeah. So now, as part of the credentialing, the HCQIA, what it did is established a 4-pronged test that basically said that if something happens and a decision is made against a practitioner, the people making that decision are immune from personal liability. And the way and by the way, if you look over here on this slide, it'll cite all of the federal guidelines, the Florida statute, plus the HCIA, where you can find this information. It says that, first of all, the action has to be in furtherance of healthcare quality. So the action done by the MEC has to really be in furtherance of healthcare quality, that the MEC or the actual investigating body has to have used a reasonable effort in obtaining all the underlying facts of the situation. If they don't expend a reasonable amount of effort in doing that, again, that it fails that second prong. The third prong is, after notice and hearing, that was fair to the physician under the circumstances. So the only way they can reach an adverse decision is to give the physician or the ability to have a hearing. And if they don't give that, then again, the third prong would be missing. Then the final action has to match the actual thing that wasn't right. So in this particular case, we're talking about credentialing. The final action that was warranted, issued by the MEC, was that appropriate in light of the circumstances of how the application looked? Ed, you were going to say something?
Yeah, I was going to say, if you're a physician who's asked to participate in peer review, you want to be asking yourself, are we making sure that that peer review is focused on healthcare quality? Is it focused on getting the facts and then making decisions based upon the facts that were gathered and for that decision, making sure that that physician that may have something adverse does have that notice and that hearing rights to for a fair hearing for the physician, and that the final action is warranted. So you want to be thinking about that as a member of the hearing committee, and well as the hospital, making sure that's all for the peer review, that's all documented in the record that these things were done.
So when it comes to this, one of the things that we had talked about in our case analysis is that there could have been multiple things done along the way before it ended up on the wrong side of the fence, right? So there's multiple things. One is net. Just know that peer reviews are intended for performance improvement and quality improvement and the healthcare quality issues, right? So it's all based about that. Now, the way to actually help a physician along is you can do several things. You can do what's called collegial intervention. It's basically, hey, buddy, this isn't coming out right, or your notes were amended. Could you do something about that? Don't look at, don't do that. Let's not do that. Let's, you could educate them. You could even have a compliance officer come and talk to them and say, hey, look, buddy, don't do this anymore. You got to stop this. Modifying the notes after the fact is not appropriate. You could actually mentor the person. You can have somebody who's of senior stature, just walk them through it and say, this is just not how we do things inside this hospital. And that all could have been done, but nobody did it, right? So in that case analysis that we went through, nobody did any of that. They just straight put them right in front of the MEC. The MEC ousted them. And that's how it landed so badly and so wrongly. Now,
but also if you're a physician and these things are being done to you, you want to be listening. You want to embrace if a senior physician is coming down and saying, look, we have some issues, you need to correct this or get some more training. Listen and embrace the advice, because if the MEC starts saying that you're ignoring this and it gets to become a bigger issue, then you might land in this whole formal investigation, formal peer review, formal hearing, that then it can be potentially harmful to one's career.
And so I mean, you could even put the person into some sort of a anger management course, a behavior boundaries course, which is getting more and more. It's an interesting term, behavior boundaries. It's got a much more of a formality and a much more global approach to helping people along. Before the peer review review takes on most of these complaints, they could have actually just had conversations. The more people embrace these steps, the easier it is to not ruin other people's careers or not go to war over something that's really silly. Because let me tell you, I mean, even individuals individual physicians can embarrass hospital system in their entirety. So there's sometimes a whole, David and Goliath scenario, and the physicians will take on the systems and beat them at it. So, so let's say that a issue gets reported, right? What then happens is that the MEC will start an investigation, and it's generally done when there is a reported activity or occurrence that takes place. And they usually find out through either routine review or somebody specifically reports it. And then the MEC says, hey, that was a serious issue. Let's do something about it. So keep in mind, the MEC, once they do decide to do something about it, as long as they can show that four-pronged test as to why it was the right thing to do to carry out that investigation, they will have immunity from those consequences of being personally liable. So again, we restate those down here just so you can keep note of that.
And don't leave once that investigation starts. Bottom line, don't leave once the investigation starts.
Yeah,
Play it out, because otherwise it's automatically reportable. No ability to defend.
Right, just like we talked about in the initial case analysis, the physician did leave right in the middle of it, right? So before it actually concluded, and they could have done a lot more. The physician could have done a lot more, but don't leave once it started. Now the investigation process, the way it normally works is there's initially an investigation interview that's done, usually of all the witnesses, of the individual themselves, and there will be either 1, 2, or 3, or 4 sort of a investigation committee that's put together, and it's usually 2 or 3 people that'll put all of that data together, gather up all the facts, and then share it with the MEC. Now, sometimes the investigative committee even interviews the patients, right? So when they interview the patients, there's actually very specific rules even as to that. The MEC cannot make any sort of a gesture or an innuendo that the physician did anything wrong when they're talking to the actual patient. If they do that, it's deemed to be crossing the line. So keep that in mind. So once that happens, and the interviewing process is complete, documentation has come in, then it's presented to the MEC. Keep in mind that competitors may serve as actually investigators, but you have to be mindful of the economic interests that are in play. But they cannot be the actual decision maker in that scenario. So competitors can play. I'd suggest not to, but if they do play as an investigative role in an investigative role, they can be challenged just based on that. So check the bylaws, see what it says about competitors and how to keep things fair. But I can totally see it where, let's say you have a interventional cardiologist in this one hospital that has issues, and now the hospital goes to the neighboring county and pulls another interventional cardiologist out of a different hospital, and then they have him investigate or her investigate the actual situation, because there's technical knowledge that not every physician knows about. So last but not least, make sure that when you do actually partake in this investigation process, do ask if the hospital has directors and officers insurance. You want to be mindful of that, just in case if somebody comes after you and you're the one carrying out the investigation. You want to make sure that there's an insurance coverage that's protecting you. So this part now we're going to talk about the process of reviewing investigation results and how it happens. So the investigation committee comes up with the actual hard facts. They get placed in front of the medical staff executive committee, and then the medical staff executive committee then either takes no action, does a letter of reprimand, or suspends or reduces their privileges, right? So that's like step number 2. And then last but not least, if step C is taken over here, it goes before the Board of Governors, and then the Board of Governors has to ratify that decision in order for it to stick. So that's the 3-step process on that. Suspensions. There are suspensions that could be put into place And sometimes there's a need for immediate suspension, which is when there is a, do you hear the dog? Sorry. Sorry about that, guys. I have a dog and she must be seeing somebody going by. So there is a, sometimes there is a need for an immediate suspension. Ed, do you mind taking care of this? And let me just.
Yeah, go check out your dog. Yeah, so yeah, there may be a need for immediate suspension if there's an imminent danger to the health of any individual. There's precautionary suspensions, which are the same as summary suspensions. The HCQIA allows the hospital to suspend someone up to 14 days to investigate without a notice or a hearing. And it's not reportable for that 14-day suspension. But if you get the suspension for more than 30 days, it must go to reported to the National Practitioners Data Bank if it's more than 30 days. Again, you have these hearing rights, et cetera, that have to be in there. And there's also as Ben will talk about, there'll be the ability of the petitioner to seek an injunction to minimize the impact of that if it's going to be reportable. I'll give me a quick example of what I've seen on an immediate suspension. I was and visiting a hospital president in his office, a couple decades ago, and it turned out that they were telling me they got a physician who's they just found out that his professional liability insurance lapse. So my advice was basically, suspend him immediately, because you really can't have a physician without insurance in the hospital, because that's a medical staff bylaw requirement. And then have him fix it. And once he fixes it, you could put him back on, no claim, no foul, other than he's suspended for a few days while he pays his insurance premium. That's an example of what can happen. Similarly, maybe you have some medical records, they haven't turned in records timely. Sometimes they suspend people if they're way overdue until they get the records up. Again, obviously not more than 14 days without some sort of hearing right.
So as we talked about this, there are progressive disciplinary actions that can be taken. Keep those in mind for either, regardless of which side of the fence you're on: collegial intervention, education, mentoring, counseling, and second opinion requirements. You can actually require a physician to be proctored, and whenever they're doing a procedure, send them into these other types of educational things. If it's like a behavioral issue, you can put them on a precautionary suspension up to 14 days without notice. That's without notice. You can actually put them on suspension. That would be, again, the precautionary or the immediate suspension, as Ed was talking about. Now, do keep in mind that if you are going to suspend someone for longer than 30 days, that it is a reportable issue to the National Practitioner Data Bank, and their substantive rights are deemed to have been stifled. So you've got to give them the whole due process before you can reach that stage. So this has got to be handled really carefully. Like between 8 and 9, there's a whole world of difference, like step 8 and 9. And then 10 is the actual disciplinary hearing takes place. Let's assuming that the action is challenged, and that's how it gets before the MEC. But now, just to walk you through the formal due process of what's involved, if somebody is going to get either their privileges revoked or reduced, or be suspended for a prolonged amount of time, the hospital system first has to give what's called a notice of reasons. And the notice of reasons has to be specific enough so that the physician understands as to what they're being charged with. It's kind of like the rules of habeas corpus, right? The notice of reasons is like the habeas corpus of this business. And then from there, the physician can invoke a hearing. They can ask for their fair day. And what'll happen is that the hearing has to be with at least a 30-day advance notice. And prior to the actual 30 days, there will be an exchange of documents and witness who the witnesses will be. That'll be exchanged back and forth between the two sides. But what'll also happen along the way is that there will be a hearing officer often appointed, and the hearing officer is really there to help the hearing panel. The hearing panel is supposed to be comprised of 3, sometimes 5, but 3 individuals that will come to a decision as to the fairness of what the violation was and the action that was that the MEC suggested. And that's how that whole formal due process works. So now let's assume that
I want to mention one real quick thing. If you're a physician and you find yourself in this due process problem, right, going through this hearing for yourself, this may be a once in a career event for you. But it's not a once in a career event for the hospital, because the hospital has done this regularly. The hearing officer oftentimes may be an attorney that does this professionally and all the time to organize that hearing. So make sure that you know what you're all doing, that you know your rights. We always say, get a counsel, get an attorney. Don't just bring in another physician friend to talk to everyone, because they may be loaded for bear in this hearing. So you have to be making sure that your rights are being protected as you go through the hearing.
So let's say that the impartial hearing panel comes to an adverse decision. Once they come to an adverse decision, you can actually still continue on the appellate road, where you can still continue. Usually inside hospital, there will be a appeals process.
Can I ask a question?
Sure.
What is an adverse action? What is the definition of that? Because you can have, you can have suspension of privileges, but you can have restriction of privileges. You can have, maybe reduce some of your rights, maybe proctoring, maybe second opinions on your selection of cases. Is there an actual definition of an adverse action?
I'm sure there is, but it's the first three things that you spoke about right there, which is reduction in privileges, revocation of privileges, obviously. But now, if they're asking you to get a proctor or to get a second opinion, that's not going to be an adverse to your privileges.
Yeah, that's sort of a temporary thing. That's a temporary thing.
But that's an adverse action, isn't it? It's not a positive action. It's an adverse action.
Yeah, but it's not adverse to the point of being reportable.
Right. But
that's what we're talking about.
Can you have an adverse action that's not reportable?
Yeah. So let's say someone may consider it adverse that the physician has to be proctored for a month, 2 months.
Right. Wouldn't that be
they may consider that adverse, but that's not going to rise to the level of being reportable to the National Practitioner Database.
Right. But there are many things that happens in hospitals that are adverse actions for physicians, but they're not necessarily reportable, because hospitals are very smart, because they can do a lot of different things and create what is an adverse action, and then they affect your business or your privileges or whatever. But they know very easily that, okay, so we didn't really cause an adverse action, so we tiptoed around the bylaws that you don't need a hearing, so you don't get a hearing because it's not an adverse action. But at the same time, physicians are being affected because they get an adverse action. It's just not reportable, but it affects their business, it affects their livelihood, affects all the things. So I'm just curious if, in just because we call it an adverse action, is there an actual legal definition, or it's just the way that things are being called in general? So,
well, it's a legal definition to the point of when something has to be reported. So those things that meet the requirements of what would fall within those types of adverse actions that get reported. But you're absolutely right. There are things that the hospital does that doesn't get to even the hearing right, that can restrict the physician for some period of time, which is, why you want to make sure, if you're on the physician side, you're having that happen to you, you're really scrutinizing the bylaws. Did they go through the bylaw requirements to be able to get even to that point? Or are they doing things that are effectively prejudicial or done outside of a peer review, giving any type of peer review right to you all, so that you could argue that, they're not protected by the privileges. I mean, the immunities that are there. Yeah.
Now, keep in mind, I mean, you can actually once there is an adverse action that even is ratified by the hearing panel, you can still go to court if you go to court, you'll generally bring about all those other claims that I talked about, the breach of contract, the due process claim, and any sort of discrimination or employment issues, or things like that that can be brought up. And there's a whole slew of them that could be, depending on the circumstances. Now, once that happens, there's a whole new rights to actually discovery. So there'll be a brand new exchange of documents. You probably get even more ability to go and depose people on the record, to get the things that you need out of the hospital system, so you can have your day in court. And the day in court is going to be hugely important. Now, this is a long battle. This is not a very short battle. This will take a year or two, but in the meantime, your privileges stay the way they were. They are not modified. They're left alone the way they are until this is actually settled. And so through that process, parties will often go to mediation. Mediation is always a required part of prior to actually trial. So somehow, somewhere along the way, either there's going to be a trial, a settlement, or what's called a motion for summary judgment, which is a much more brief level of reaching an actual final judgment. So these are the basically several things you can do in court. And again, this is a costly battle, and it's a long battle. But as you come across issues having to do with medical staffing privileges, medical staffing issues, we're here to help you. We'll help you sort through whatever you need to get you through your predicament. And if you have a legal counsel that you already use, please feel free to call them as well, and they should be able to help you. Any other input at this juncture, guys? Okay, we're
Great.
good.
All right.
I think
Great
we're
presentation.
7:35. We're
Thank
like
you.
5 minutes
Thank you,
over.
Joe.
So
Okay, great. Thank you again for your time
Thanks,
today and your support for South Florida Hospital News, the Broward County Medical Association, and Mirza Healthcare Law. And we hope to see you next time on June 1st. And Ben, what's the event coming up on June 1st? What is the?
you caught me flat-footed on that one, Charles. I'm
Okay,
sorry.
the June 1st,
Stark Law,
June
right?
1st event is going to be Healthcare Insiders linked to fraud and abuse and safe harbors, I believe that's what
Yes,
it's gonna
that's
be.
right.
Stark Law and Fraud and Abuse. Yes.
Yeah, so again, that's going to be on June 1st. It'll be the same time. It's a Tuesday, first Tuesday of the month at 6:30 to about 7:30. And we want to thank you, and we're going to have this up on the website probably within a couple of 3 days. If you would like to take a look at it again or recommend it to a friend, it'll be up on the South Florida Hospital News website in my e-newsletters, and also on Ben's website and through his e-newsletters. So again, thank you very much, and hopefully you'll join us again. Thank you.
Thank you, guys. Bye.
Hi, everyone.
Bye.